appeal in the matter of the public institution, the social security, and Al-Rajaan and others are.
Good morning, Mr. Pitt. We'll take a break at around about 11 and again at around about midday.
Understood. Thank you very much. So I was going to move on, but before I do, there are about 4 points I just wanted to wash up from yesterday. The first, if I may, is actually a piece of homework that Lady Justice Carr set us in relation to how one might go about actually doing the analysis of Article 23, a sort of rubric for Article 23. We've set it out in 4 questions and written it down. Might I just pass that up to the...
Yes, by all means, thank you.
Oh, yes, sorry.
Very much.
So we've set out the head of Article 23, not the other ingredients like the in writing and so on. We've included the paragraph from Hal-Dufferin. We then tried to explain how one can characterise that more pithily, and then broken it down into 4 stages. Now, we're not saying that this is the only order.
No, I understand that, and I also have revisited paragraph 31 of Powell and Dufferin, and I do think that that does suggest, as the judge indicated, that the first question is logically, does, in connection with what particular relationship was the EJC agreed?
You can read it that way. The way that we've put it is by looking at the dispute first.
Yes.
And the logic of that, of course, is that in the end is the question that you want to answer. And therefore, focusing on the dispute and then thinking about the legal relationship may be of assistance, particularly since part of the problem with the way the judge approached it was because he didn't look at the way in which the dispute arose from relationships until, I think it's section H. You don't ask systematically the question, what was the relationship in relation to which the dispute arose, where we would say it's the relationship between Mr. Al-Rajaan and his associates and the bank rather than the bank and PIFs. And we do recognise, of course, that you then do need to consider whether or not there was a jurisdiction clause in relation to the particular legal relationship. So even if you answered question 2, as we say you shouldn't, as covering the PIF's bank relationship, you still have to apply the strict construction to that next question 3 about particular legal relationship. And then, of course, what we also say is very important is 4, that notion of consensus, which is emphasised in the case law in relation to it. But we recognise that you can do it in a different order, but we've tried to assist by providing that rubric.
Thank you very much indeed. Thank you.
So the second point I just wanted to pick up from yesterday was again a point that was raised by Lady Justice Carr about the term legal relationship and the interaction with contractual relationship. And I think it's worth bearing in mind actually what we saw in Powell-Dufferin, where we were concerned with the Articles of Association. And of course what we saw in Powell-Dufferin was a reference to the fact that in different national laws, Articles of Association of a company may be seen as contractual or non-contractual, indeed possibly even sui generis it was put. And therefore using that sort of terminology of legal relationship ensures that you don't exclude those sorts of arrangements. That doesn't mean that in practice you're not going to be dealing with almost invariably, so far as we're concerned, contractual relationships in respect of which exclusive jurisdiction clauses have been put in place.
Can I ask you a question arising out of your submission yesterday, that you accept that a concurrent tortious claim to the contract would fall within scope? What of a negligent misrepresentation claim, completely self-standing, not to do with the contract, or negligent advice claim by the bank to your client, within or without?
I think there are circumstances where, depending on the nature of that claim, it could potentially be within, because we do have to accept that you can have concurrent tortious actions and therefore...
But ignore concurrent, tortious.
I'm
Ignore concurrent, so I'm saying not concurrent.
Non-concurrent. But in those circumstances, sorry, I'm taking it from the concurrency through to recognising that in relation to the relationship, one can also have tortious claims. And yes, I think there may be circumstances where, yes, you could have a situation where between the client opening the bank account and making provision in relation to what was happening in that bank account, if they were negligently advised, it may well be that there is effectively sufficient connection with the relevant legal relationship in those circumstances. But of course there you are dealing much more directly with the position of the bank providing direct advice to, in this instance, PIFs. So yes, but and therefore we recognise that there are matters of degree of connection, which is why the strict construction issues become more important. But we don't want to say, no, it is impossible that those sorts of other arrangements may well fall within the scope of a jurisdiction clause.
Thank you.
The third thing, I think, is just to go back to the point, again, question from Lady Justice Carr about the nature of the legal relationship. I referred to it as being a bank account holder and then possibly investment holder in relation to certain relationships with certain of the PICTE accounts. I think the first point to reiterate, just to be really clear, Mirabeau, single bank account, no management or advisory services, straightforwardly bank account holder. In relation to PICTE, there's no investment or management advisory agreement. So I don't want to give the sense that if one talks about investment holdings, one's talking about investment advice or management. It is correct that the wider PICTE group did manage certain investments ultimately owned by PIFs, but those were subject to separate contractual arrangements. And so we say there's no contract between PIFs and Bank PICTE for that work, and subject always to what's being said against us in relation to general business conditions. And I think it is worth noting that PICTE's own supplemental skeleton, paragraph 7b, and just for your notes, CV4 42 1058, recognises that the investments in respect of which they say claims should fall within the exclusive jurisdiction clause. They say those investments were placed or managed by PICTE subsidiaries or wholly owned entities, not PICTE itself. And then I think the fourth point, just to pick up from yesterday, was actually just something where I think I've just effectively read too fast. We were talking about the general business conditions and discussing why it is that we don't take some sort of refined view about the precise terms of those as affecting our submissions. I think it is just worth bearing in mind, if we could go to paragraph 81 in the judgment. I think I took you to this, but I just want to confirm that we're talking here about the account opening terms. And of course, what it says is this account is subject to the general business conditions. And that's how all of these arrangements are structured. And that's why we say reversing in those general business conditions doesn't expand the nature of the legal relationship, because it's always to do with this account. So those were just 4 points that I was picking up from yesterday. I was going to move on then. In the light of the submissions made yesterday and the various issues canvassed, I'm not going to deal in detail with issues to do with issue 3. I think we've dealt with most of the points that are actually raised against us in relation to issue 3. Issue 3, you'll recall, is the argument that, in fact, all of A, B and C, as it's put, should fall within scope in relation to the Swiss law interpretation of the EJCs. Now, the judge, even following his broad interpretation, said that was not correct, and we said it's absolutely right. And we say the simple answer overall is there's just no basis for applying proper interpretation of Article 23 compliant with European law and including those Category C terms within claims within the scope of the EJCs. But I'll come back to that in reply if and insofar as it's necessary. I think we, in talking about the matters dealt with in the judgment yesterday, I hope I canvassed the significant differences between the money laundering and secret commission arrangements. That then takes me to issue 4, which is the application of Article 6 of the Lugano Convention and Article 6.8, the Brussels Convention and Regulation. Now, this issue is obviously important in relation to those Category C claims, or indeed Category B and C, if this court were, for example, only to decide that the secret commissions fell within the scope of the exclusive jurisdiction clauses. And what we say is that the judge seriously misdirected himself as to the relevant law in relation to the application of Article 6.
Sorry, just that parenthesis.
Yeah.
I hadn't understood you to be tilting at all for a sort of another option, which is A's in but B and C are out.
We're tilting for all out,
yeah.
And all I'm saying is if this...
Anything could happen.
Yes, I don't want to presume the way in which this court may consider matters.
Thank you.
And therefore I was just placing that parenthesis.
Yes.
In relation to Article 6, it's perhaps worth just turning up the original version of it. It's Authorities Bundle 5, tab 53 at 1771. Now this is the original version of the Lugano Convention, and as we canvassed looking at the authorities yesterday, Article 2, which is on page 1769, enables defendants to be sued in their place of domicile, and then we turn on to 1770, and under the heading Section 2 Special Jurisdiction you have Article 5, and then over the page 1771 Article 6. And Article 6 provides, a person domiciled in a contracting state may also be sued where he is one of a number of defendants in the courts for the place where any one of them is domiciled. And that is the provision that was put in place originally. And therefore, what it provided for was domicile in relation to a particular defendant, providing that anchor, as it's referred to, but enabling other defendants to be sued there as well, with no apparent qualification at all. And that, of course, is what was at issue then in the first case really to consider this in any detail, the Calfellis case. And we see that authority at Authorities Bundle 4, tab 37, at page 1293. Perhaps just worth turning back a page to 1292. Again, it's a preliminary reference. Preliminary reference from Bundesgerichtshof. You see this at paragraph 6. Essentially, to ascertain for Article 6.1 of the Convention to apply, must there be a connection between the claims made by the same plaintiff against several defendants, and if so, what the nature of the connection is. In other words, the reference is saying, look, are there any qualifications to that broad provision in Article 6.1? And you'll then see, in relation to this in the sideline passage, and I just invite you to read the sideline passage from paragraph 8 down to paragraph 13. So what we're seeing here is the court considering the breadth of Article 6.1 and saying, look, if you don't have to have any connection between the claims that you're bringing in the state of domicile of one of the defendants, you could just effectively undermine the whole operation of Article 2. But the qualification that is introduced is very, very limited. Because what is said in 13 is that there must exist between the various actions, so the actions actually being brought against the multiple defendants by the same plaintiff, a connection of such a kind that it is expedient to determine those actions together in order to avoid the risk of irreconcilable judgments resulting from the separate proceedings. So the only qualification is essentially look at the cases that the plaintiff is bringing in the jurisdiction of one domicile defendant and ask yourself, is there a connection?
Look at cases in which the plaintiff is... I just missed it, sorry. Look at the case in which the plaintiff is currently suing or suing in this jurisdiction.
Bringing proceedings.
Thank you.
Thank you, sorry.
No, it's my fault. I interrupted. Right, look at cases in which the plaintiff is bringing proceedings in
the state of domicile of one of the defendants, and then ask whether there is a risk of irreconcilable judgments in relation to the others of those claims. It's very, very straightforward. Because in this case, there isn't an argument about irreconcilability. It's accepted that if the claims in relation to Category C were to be heard in Switzerland, there would be a risk of irreconcilability as compared with the money laundering claims that are being brought against the 22 defendants who are being sued in London. So there is no issue there. And that is the end of the analysis. And the essence of the problem with the judge was that he didn't stop there. He started thinking about whether or not other claims might be brought in Switzerland under Article 23, and then carried out some sort of balancing exercise. And that was just wrong. And one can see...
Are you suggesting that the exception is limited to the actions must have been brought, must be in existence?
Yeah, they must be in existence. Yes, it must be. Because the question you're asking about is about whether you can sue people in the jurisdiction.
So what if the proceedings are issued the next day? Anyway, your position is that the only relevant, point one, the only relevant consideration can be proceedings which are actually up and running.
Well, you're asking, what is being asked is, can you sue someone? Sorry, I don't mean you, my lady, but one is asking the question whether or not it is possible to sue a defendant in, for instance, the UK when you have claims being brought in the UK.
So just on this narrow point, yes or no, must the proceedings be in existence to be relevant? And so it's impermissible to look at potential future proceedings?
In relation to this, yes, because what you're doing is assessing whether or not the extant proceedings risk irreconcilable judgments. But they must be being brought. The key point is what one is doing is looking at the irreconcilability of the proceedings that are being put forward by the plaintiff in the state of domicile of one of the defendants. You are not looking at actual or potential proceedings being brought by the plaintiffs in other member states. That is not what this test is concerned with. And that is the critical issue. So even if your ladyship were to be considering potential claims, it still has to be focused on what is going on in, for these purposes, I'll focus on the UK. And so, in these circumstances, the key point is that even if there were extant proceedings in Switzerland or Luxembourg or some other state, that is irrelevant to the assessment of the question under 6.1. As it is, there are no extant proceedings in Switzerland or Luxembourg in relation to these matters, but that is not relevant to the assessment of this test. What you had was a very, very broad provision in the original Lugano Convention and Brussels regulation, and then a narrow qualification being introduced to it. And so if I could then just move briefly through one or two of the other authorities. Authorities Bundle 5 at tab 55. I'm so sorry, I think I've got the wrong reference there. So Authorities Bundle 4, tab 42. I apologise. It's beginning at page 1402. And this was a case, Reichmontage, where a claim was being brought. It's another reference, preliminary reference. Where a Liechtenstein company brought an action before the Austrian court and joined a German entity under 6.1, or argued that German entity could be joined. And it transpired that the claim against the Austrian entity, person, was in fact inadmissible under Austrian law. So you had a funny situation where actually as soon as it started, it could be said that the action was actually inadmissible. And so the question was being referred, does that still mean that you have an anchor for the purposes of Article 6.1? And if one turns to 1415, you see the question that was being referred at paragraph 15. I should add that by this point, the Brussels regulation, Article 6.1, had been modified to include that qualification we saw set out in paragraph 13 of Calfellis. So the legislation had been changed to reflect that condition. And one can see that, if it's useful for the court, if one goes back to page 1406. Sorry. Yes, in the Advocate General's opinion, paragraph 7. So that change just reflects the qualification that was put forward in Calfellis. And it was later introduced also into the Lugano Convention, which is why we look at it in those terms. But it was by reference to that phraseology that the question in 15 is then answered. And I would just ask you to read paragraphs 26 through to 33. Beginning on 1416 here.
Yes.
So 2 points to draw from this. The point of assessment is at the point that the claim is brought in the member state where the defendant is domiciled. One doesn't then roll forward and think about whether or not that claim might be admissible and so on. That's made very clear here. So the admissibility issue that arose was just to be ignored for these purposes. And then the discussion one has about this doesn't involve any sort of question about viability of claims or other considerations. It's simply this question of the risk of irreconcilability with, in this case, the claim against the German entity. And what is said in 32, and I just note this, is the constraint in 6.1 is referred to there as being not permitting someone to bring a claim for the sole purpose of removing them from their place of domicile. They can't be joined for that sole purpose is what is said in 32. The reason I highlight that is because that language is then referred to subsequently. But again, the point here is that the court is construing that qualification to the breadth of 6.1 extremely narrowly, both temporally and in terms of the scope as to what matters. It doesn't matter whether or not you could have brought a claim in Germany against the German entity or are intending to. One doesn't need to get into any of that discussion. The next case I want to go to is at Authorities Bundle 5, tab 44, page 1467. And if we could pick it up at 1501. Paragraph 38. One of the questions being asked here was, did it matter whether the different claims being brought by a plaintiff were on the same or different legal bases? You see that set out. The answer to that, rather the question being raised in 38. And then you'll see in 39 the answer to that, referring again to the Calfellis case. I'll just ask you to read 40 and 41.
Sorry. Page.
1502 is 40 and 41. So just to emphasise in relation to 41, the issue for the National Court is to assess whether there's a connection between the different claims brought before it. So I think this perhaps goes back to the question that Lady Justice Carr was asking earlier. That's to say, a risk of irreconcilable judgments if those claims before domicile court were determined separately, and in that regard to take account of all the necessary factors in the case file, which may, if appropriate, yet without its being necessary, for the assessment, lead it to take into consideration the legal bases of the actions brought before that court. Now, the reason I just emphasise this is because there have been references in the submissions from the respondents and indeed the judge's judgment, we'll come on to this reference to the case file. But it's not talking about the case file in some broader sense as to whether or not there are or aren't cases being brought in other jurisdictions. What it's dealing with here is what are the nature of the cases being brought before this court? That's all that's being talked about, and it's in the context of a question about what the legal basis for those cases are. So, briefly then, the next case I'm going to go to is at tab 48, which is the CDC case we saw yesterday. As I mentioned yesterday, there were a number of elements to the CDC set of references. Part of it was in relation to Article 6. And if we could pick it up, the relevant part of the court judgment, it begins at page 1650. Now, you'll recall I mentioned yesterday that in relation to CDC, this was a cartel damages claim where the anchor defendant was an entity called Evonik Degussa, and that in fact what happened was the claimant settled with Evonik Degussa, but still wanted to proceed in Germany against all of the other defendants that it had brought in under Article 6.1. So you see the question posed at paragraph 15, summarised, the reference question. And then you'll see the formulation in paragraph 20.
Just hold on a second.
I'm so sorry.
They don't write short sentences, do they?
No, sadly not. They write short judgments with very long sentences.
Right, well, I've twice got halfway through before losing the thread. I'm going to start again.
Yes, well, I think it might be a product in part of working language often being French and the structure of subclauses then being translated.
Yes?
So, again, I think this fits in with what Lord Hope also referred to as the European Court's tralitition approach to jurisprudence, which is to repeat chunks of different judgments over time. But again, what we're seeing in CDC is, notwithstanding the fact that you have settlements, one ignores that, one looks at the various claims brought before the court by the same applicant against the various defendants and simply look at those issues.
Now, as I'm understanding your point, it's that even in cases where the anchor process was not valid, or in the case where the anchor process is settled, nevertheless the focus remains on what's going on here, or
yes,
as the case may be, not a comparative process about what's going on here and what's going on there. Although in order to decide the question of irreconcilable judgments, one inevitably has to have an eye to what the remaining questions might arise elsewhere.
No.
Not at all, even then.
No, because you're looking at
it's entirely
it's within the scope of the cases being brought. You're looking at the irreconcilability of the...
Sorry, how does the irreconcilability arise if you're not looking at another jurisdiction?
It's the irreconcilability of the cases, because what you've got is a case against an anchor defendant being brought by a plaintiff, a case against a non-anchor defendant who is domiciled elsewhere but can be brought in under Article 6, and all you're asking about is the risk of irreconcilability between those two cases, or the multiples of those two cases. You don't need to look at whether or not the issues arise, or if there are separate claims elsewhere. I'm sorry if I'm being...
I see. But so the second claim would otherwise be tried in, say, Geneva?
Exactly. Yes, I'm sorry. I should have put it in counterfactual terms. You're quite right, my lady.
You're asking, if they were not brought in under Article 6 and this was dealt with in Geneva,
yes,
that's the irreconcilable.
Yes, that is the way correctly to put it. Absolutely. But it's not.
You don't look and say, we've got some here, and we'll assume for the purposes of this that we don't use Article 6, and we've got some there, and work out what's for the best.
Exactly. That's the simple solution.
All of this is.
That's all, and all of this is just showing that very basic approach, the limited qualification in Calfellis, is then carried through even when you get these funny situations like inadmissibility, like settlement, and so on. There's no suggestion that you do anything else, because that isn't the right way of approaching any of these cases. And if I may just pick up for your reference paragraph 27 and 28, I've just directed the court to in relation to this CDC case. So that's pages at the bottom of 1651. And then I'll just highlight 29. It follows that where proceedings are instituted, claims are connected within the meaning of 6.1. The court seized of the case can find that the rule of jurisdiction laid down in that provision has potentially been circumvented only where there is firm evidence to support the conclusions that the applicant artificially fulfilled or prolonged the fulfilment of that provision's applicability. And what that was talking about in this case was, had they intentionally deferred the settlement with the anchor defendant in order to suck everybody into Germany and then settle with them afterwards. But that's the only qualification that's being raised here.
Well, that's just abuse, isn't it?
Well, that's what's then argued about as to whether it's abuse. I'm going to just deal with a couple of... I think in discussions, in academic discussions, I think that's what has been talked about, yes, as to whether or not that's really a qualification at all at that point. But if I may then go back to Authorities Bundle 3, tab 25. Relatively recent case of Mr. Justice O'Brien. And I'm not going to look at the facts in any detail, I'd just like to pick it up at page 765, paragraph 68. So this is consideration of 6.1 in relation to some Swiss co-defendants. You see at 68, the Campbell co-defendants are all domiciled in Switzerland, subject to Lugano. I'm satisfied that the requirements of 6.1 are met in the present case for the following reasons. Firstly, the English court has jurisdiction over Udale, an English company. That's 69. And then if we go on to 70, and then he works through various reasons for that. Secondly, the claims against the Campbell defendants are closely connected with the claims against Udale. And then if we go on to 71 on page 768. Thirdly, in the light of this close connection, which of course we do have in this case, it's expedient to determine those claims together to avoid the risk of irreconcilable judgments resulting from separate proceedings against Udale in England and the Campbell co-defendants in Switzerland. And he then goes through a number of considerations. I do just want to pick up 6.
Sorry, so he does consider as relevant proceedings abroad?
He refers to proceedings abroad, yes.
Well, it's part of his reasoning. And are these future or actual proceedings?
I think those are actual proceedings in this case.
Right,
but I'm not sure whether all of them are actual. I think one needs to be cautious because what you're dealing with here is, I think as it was put, the counterfactual as to whether or not if these are allowed to continue or are being brought in another state. So I don't think, although he's referring to the possibility of these claims being brought elsewhere, I don't think what we're talking about here is him carrying out any sort of balancing exercise. Indeed, that is not what is being assessed in this paragraph. Indeed, if one goes down to subparagraph 6, you see the Campbell co-defendants, the Swiss defendants, made submissions on the meaning of the word expedient, which was directed at or came very close to relying upon forum non-convenience considerations such submissions were misguided in the context of Article 6, expedient means appropriate, i.e., there is such a risk of irreconcilable judgments that it's appropriate to hear the claims together. This is clear from the language and purpose of the Convention in facilitating the recognition of judgments. Now, I think that my learned friends seem to say, well, appropriate means that there's some sort of balancing or consideration of other actions can be brought into account. That is not authority for that proposition at all. Sorry, I've just... Sorry, I was going to go to the next authority, tab 28, just concerned my lady, I think, is reading some more of 10.
Thank you, sorry. Yes.
So, tab 28, I just want to go to the Kolomoisky case. And in essence, this was an appeal against a judgment of the court below in Kolomoisky, where claims had been brought against two English entities, and various Ukrainian entities had then been various other entities had then been joined. And what was alleged was that the claims had been brought against the English defendant solely for the purpose of providing an anchor to bring in the other defendants. And what was being said was, well, look, if we go back to the language that was used in cases like Freeport and Reichmontage, the purpose of that qualification to Article 6.1 was to stop people using anchor defendants, bringing claims in, for instance, London, in order solely to bring in other...
What help are we getting from this decision, which I think was a majority decision on the question of a false anchor, basically?
Well, what you get from it is a conclusion. I'll skip through a very full consideration of all the previous authority. And a conclusion, if we go on to page 952, the rejection of the idea that, in fact, there's a sole purpose rule. In other words, you can't rely on 6.1 if your sole purpose is to bring in defendants from outside into, in particular, the UK. You see that at 102.
Is that of any relevance here?
Well, what it's illustrating is the fact that you don't have broader considerations. So even if you are considering simply using an anchor to bring in a party, and your sole purpose for suing the anchor is to bring in that other party, no other balancing exercise is required or relevant here.
Right, so it's somewhat the other side of the coin to cases where you start the proceedings and they don't have a life.
Yes, exactly. But it's, again, illustrating the limitations of the approach that's required under 6.1. And then I just do need to pick up at 974, because I think this paragraph 191 is cited against me.
Sorry, paragraph?
191. And here there's a consideration of the term expedient. And it's said that expedient in this context means something more like desirable than practicable or possible. I think it's then said, well, that suggests that one can carry out a broader assessment of what constitutes expediency in assessing the application of Article 6.1. And the answer to that is no. None of this is qualifying the strict test in Calfellis. And actually the reason there is a debate about the meaning of expediency was because it was recognised that it was not possible to consolidate the relevant actions in the UK. And therefore it was being said, well, if it's not possible to consolidate them, then it can't be expedient. And the judge is saying, no, even if you can't consolidate them, the meaning of expedient here is simply desirable. Now, one other case reference, just very briefly. It's Authorities Bundle 1, tab 14. Beginning at page 268. And this was a claim by Aeroflot, who wanted to bring claims in London against various entities who were referred to as Services, Holdings, Cyprus and Finance, using Article 6.1. They had anchor defendants in London. And those other entities were domiciled in Switzerland and Luxembourg and Cyprus and elsewhere. And the consideration of issues in relation to Article 6.1 begins at page 305. And I just ask you to read paragraphs 111 through to 113, if I may.
Again, paragraph 113.
Exactly.
Foreign proceedings are seen to be relevant.
Well, no, they're not relevant. What's being said is that the consideration of a close connection between the other proceedings is irrelevant. That's what's said at the beginning of 113. If Aeroflot pursues services, it must do so on my ruling in the Lausanne court, and if it pursues Cyprus, it must do so in arbitration. So necessarily there are going to be different tribunals that deal with each of these claims. Well, that's true. There's no way in which there is necessarily going to be complete non-fragmentation. But what was being said here was the fact that there will be other proceedings in other places. What was being said by the defendants in this case was the fact that there are other proceedings in other places. Those are more closely connected to the proceedings you want to have dealt with in London. And the judge is saying, no. That degree of connection with the foreign proceedings is irrelevant. So your ladyship is right that there are references to foreign proceedings, but what's actually being said is that the connection between them is irrelevant. So if I could then go to the judgment in this case. And we should pick it up, it's in section J, which begins at paragraph 403.
What paragraph?
403.
Yes.
So here is under the heading Article 6, Article 8 jurisdiction. And we then have reference to what's being considered in 404, which is essentially the C claims and certain claims against Mr. Mirabeau in relation to the time after he was ceased to be a partner. And then it also arises in relation to certain of the other claims, in relation to certain of the other individuals. That's at 405. And then if we pick it up at 409...
Well, 408.
Yes, 408, I'll come back to, but it's difficult to understand what 408 is saying because the terms of Aeroflot that are then quoted do not work on the basis that they must be being brought elsewhere. Your ladyship is absolutely right that in the paragraph 113 that I referred you to, the judge did look at the situation where those other claims which would be governed by exclusive jurisdiction clauses were being brought elsewhere, but said they were irrelevant. But it wasn't, the fact that he thought about that on a hypothetical basis doesn't mean that one always assumes that claims that can be brought under Article 23 and must be brought elsewhere if they're to be brought at all are in fact being brought. So we don't
I
accept...
understand that they're not in existence by definition.
Yeah.
But there's no challenge to the judge's approach in 408. Ignore what's said about Aeroflot, and there wasn't a challenge to that below. So for the purpose of Article 6...
Well, I think in relation to the position taken below, and I'll be corrected by those behind me, the position was that there were not claims extant, and that was, if and insofar as that was relevant to the consideration of under Article 6, which we say it is not for the purpose of this question of irreconcilability, one couldn't assume that the claims were actually going to be brought in Switzerland because that was not the position.
So this was an assumption in favour of the defendants?
Yes.
On a matter which you say is irrelevant anyhow?
Yes. We'll then see at 409 the principles relating to Article 6 that are then articulated. You'll see there that in 410, what is set out is the current version of the Lugano Convention, Article 6.1. And then I just invite you to read paragraph 412. Because this is the only reference to Calfellis in the judge's analysis. And what he's failing to do here is recognise what was actually being done in Calfellis by the introduction of that qualification to the generalised provision in Article 6.1. And that then affects the whole way in which he considers the issues in this case, because he did not appreciate the narrowness of the qualification that was being made in Calfellis. Now he refers in 413 to certain of the recitals to Brussels regulation, which talk inter alia about trying to avoid fragmentation of claims, but not trying to make it absolute. And in 414, there are citations of Freeport and Anderson, to which I've taken you, 415 Reichmontage, and various other cases. 418 picks up that point that I directed you to in relation to paragraph 191 of Kolomoisky. Then we've got reference in 419 to Terre-Neuve. Then we move into, at 420, consideration of questions of irreconcilability. And as I say, on this appeal, there's no issue, but there is a risk of irreconcilability between the Category C claims and the claims otherwise being brought in London. And that runs through to 826 with some citation of other bits of Terre-Neuve. And then at 427, you'll see the judge then poses the question, the conclusions I've reached in relation to the EJCs give rise to the question, what should the court do where a claimant is required to sue a defendant in an overseas jurisdiction under Article 23 in relation to some claims, but seeks to pursue in this jurisdiction connected claims against the same defendant or connected claims against another defendant in reliance on Article 6. Well, first of all, obviously, and 427, it's not that we're required to sue a defendant in an overseas jurisdiction. It's if we do sue them, and Article 23 applies, as he says, then we can only sue them in that jurisdiction. But we say, in embarking on this analysis, there is a grave danger that the judge has simply missed the central point of the qualification in Article 6, because he's posing the question in the first place. Obviously, it's open to a judge to pose a question of this sort, but we say the answer is very straightforward in these circumstances, given the narrowness of the qualification in Article 6. But instead, what we get is a discussion of various arguments that were put forward. And picking it up at 430, he said, I'm inclined to agree that the words to avoid the risk of irreconcilable judgment resulting from separate proceedings would tend naturally to refer to the avoidance of risks arising from claims against the anchor defendant and the proposed Article 6 defendant being proposed in separate proceedings and resulting in irreconcilable judgments. Well, it's more than tend naturally. That is the interpretation of those words. And then he says, there's no indication in the wording of Article 6 or the legislative recitals that the legislator had in contemplation at all a situation such as arises in the present case, where the court contemplates assuming Article 6 jurisdiction over a defendant against whom related claims must, however, be pursued in another convention state, which is also its state of domicile by reason of an Article 23 jurisdiction agreement. Well, it is coincidentally the state of domicile. Article 23 agreements obviously can be for state of domicile or otherwise. So that is a dangerous assumption to be making. But the point here is that the judge never engages with the essential reason why the legislator included that condition, which is the reasoning in Calfellis. And that's the error here. It's a narrow qualification, and the judge failed to recognise that. Because he then goes on in 431 to say, it doesn't follow, however, the legislator must have been assumed to have taken the view that were the situation to arise, such related claims would be irrelevant. Well, we say, actually, that's clear from the case law and the reasons that it was irrelevant. On the contrary, the fundamental policy of the Lugano Convention and recast Brussels is that defendants should be sued in their state of domicile. Well, yes, but that doesn't mean Article 23. The fact that it's coincidentally domicile, it's not relevant here. Save for a few limited exceptions, that must be properly confined so as not to undermine that policy. Justification for assuming jurisdiction Article 6 as a derogation from the basic rule is the desirability of avoiding concurrent proceedings and irreconcilable judgments between different convention states. Well, that is undoubtedly underpinning what is going on in Article 6, but the structure and terms of Article 6 and the condition are not saying you get into this wider exercise of assessment. And that is precisely what he then goes on to do here in the following paragraphs. And then he seeks essentially to distinguish the elements that I've referred to in Freeport at 434 and CDC at 436. And then you'll see that there's an extensive citation and discussion of Aeroflot from 437 onwards. And conclude where he picks up at 440. So at 439 he's saying, well, look, there's a difference between the position in Aeroflot and the position here, because in that case it was different defendants, not just different claims against the same defendant as it occurred in this case. So it was different defendants who were subject to Article 23, and we say that's irrelevant. And then he talks about the additional forum being Luxembourg, and therefore a diversity of forums arising. Well, again, that is not material to the Article 6 consideration. And at 440, he says, Aiken stated in paragraph 112, for some reason the numbering in the judgment is slightly different from the numbering that we saw. That was 113 in the version in the authorities. That it was irrelevant to consider whether the claims against holdings were more closely connected with the claims against its subsidiaries than they were against the claims of the anchor defendants. It may have been a relevant factor in that context that since the claims against holdings couldn't be pursued in the same forum as those against services or Cyprus, there was in any event going to be fragmentation of proceedings as regards the claims against the various corporate defendants. So what we're seeing there is, to some extent, speculation about what was going on in that judgment, but it illustrates the sort of exercise the judge is getting himself into here, considering what are the differentiating factors, carrying out some much broader balancing exercise in order to carry out a consideration whether or not claims that would, if they are to be brought under Article 23 against the banks in relation to secret commissions, have to be brought in Switzerland, and then saying, well, how do we weigh all this up? How do we look at the connections between them? How do we carry out this balancing of expediency? And we say, that's wrong.
But if there is going to be fragmentation anyway, if there are going to be claims in other countries, is it not relevant to consider the degree of irreconcilability as between those different claims?
No.
You just have to look at what's
Just look at the, yes, you just look at the irreconcilability between the claims that are being brought in for these purposes of London and the ones that are proposed to be brought in London in relation to them.
You don't
need to look at anything else, because that way you would get into a very difficult and potentially arcane argument about what might be brought, when it might be brought, how it was going to be brought, and what.
What if they're extant? If there are extant proceedings, as there were in Aeroflot?
If there are extant proceedings, the position is the same. And in an Aeroflot, it was very clear. It's irrelevant.
So you don't take it. You don't. What if on one sub issue on an alternative point, there was a risk of an irreconcilable judgment, but the rest of the judgment, or the separate proceedings, the risk of overlap was non-existent. Compare that situation with a case where there was enormous risk of overlap on the central issues in the case. You say that when considering expediency for the purpose of Article 6, you simply ignore the difference. And you say you treat one the same as the other.
I'm in considering irreconcilability between the claim that's being brought in the state of domicile and the claim that's being brought forward. If you only had irreconcilability in relation to some tiny sub issue, it's not clear whether or not overall one would be saying that one has a sufficient risk of irreconcilability in relation to the overall thrust of the claim that we're talking about.
But then that links in with what my lady's saying, that there is some sort of examination, there has to be some sort of examination of the degree of the risk, the extent of the risk to determine expediency.
Well, yes, but the degree of risk of irreconcilability undoubtedly has to be considered between the case that's being brought in London and the case that's proposed to be being brought in London. What it doesn't do is then consider whether or not there is a differential level of irreconcilability with other cases that either are in the extant situation or might be brought elsewhere. And the fact here is that there's no challenge on irreconcilability, and therefore that is not an issue on this appeal, whilst I quite understand the nature of the question that's being posed.
Sorry, Phil, explain that last comment to me. I have missed that nuance.
So in relation to this appeal, it's not suggested that there is...
By you?
Or no, there is no argument that there is a real risk of irreconcilability between the money laundering claims under Section C being pursued against the banks and the other defendants here, and the claims that are actually being brought in London against Mr. Al-Rajaan.
As in, it's accepted there.
Yeah, it's accepted.
Sorry,
yes. Sorry. If I wasn't clear, I apologise.
No, not at all. Thank you.
I'm conscious of the time. I'm almost finished in relation to this topic.
Well, shall we? If it's going to be only a few minutes more, would it be more convenient?
Yeah, if the court would indulge me, that would be helpful. So we say that 440 is not only speculation about Aeroflot, it's not recognising, in fact, that the court there was saying it doesn't matter that there were proceedings extant elsewhere. That is irrelevant to this exercise. And then what the judge does in 441 is say, even leaving that point aside, however, Lord Justice Aiken's reasoning cannot, in my view, simply be transposed to a case such as the present one, where the question is where two sets of claims against the same defendant are to be pursued. And so this is this issue about whether or not the fact that you would have secret commission claims against the banks in Switzerland and money laundering claims in London can be ignored for these purposes. And you'll see at 442, he then starts talking about all of the factors in the case file. Now, as I explained, when that language was used in Freeport, it was clearly concerned with the case file, concerned with the claims that were being brought in for these purposes, London, and the ones that were proposed to be brought in London, relying on 6.1, not some broader case file in relation to other matters. And of course, there is an underlying danger in relation to the approach the judge is adopting here, which is it undermines the concerns about legal certainty that are clearly motivating the strict approach we have seen in all of the case law in relation to the application of 6.1, even in relation to cases where matters are inadmissible in relation to the anchor defendant, where they're settled in relation to the anchor defendant. Nonetheless, a strict approach is taken to that limited qualification. So the approach that is being adopted here would undoubtedly undermine that sort of certainty and the strict approach to Article 6.1 that we've seen in the case law. And therefore, we say that the approach that's adopted here is simply wrong. You cannot completely avoid fragmentation, although that is part of the goal of the Brussels Regulation and the Lugano Convention. You can't avoid fragmentation so long as you recognise the existence of exclusive jurisdiction clauses. That will exist as a possibility, particularly in multi-party cases. But that is not enough and is no good basis to qualify the clear case law in relation to these issues. So that is why we say actually the essence of the error here stemmed from the failure to recognise the limited qualification back in Calfellis. There is, of course, a further ground of appeal that we refer to in relation to this, which is even if we're wrong in relation to this, which we say we are plainly not, that nonetheless the assessment was of connectivity and relative connectivity was carried out wrongly. For those purposes, I will just refer to our skeleton arguments, which are at Core Volume 1, Tab 10, page 95, paragraphs 60 and 61, and in relation to our supplemental skeleton, Core Volume 4, Tab 41, at 104-49, paragraph 60 onwards.
That's ground 7.
Yes, exactly. Quite right, my lady. At that point, I will pause, and I'm grateful.
Thank you. Where are we going next?
Sorry?
Where are we going next?
Issue 1, so back to the in-writing issue.
All right. Well, we'll resume at 1:15.
All right. Just to let you know, ladies and gentlemen, I'll have to keep the live stream going. I'll stop it break. So it just means we're being recorded the whole time.
I'm going to put some stove there.
Yeah.
Can I put one on top of that as well? Can I be okay? Well, I'll let you come and go first.
No one's going to accuse him of being a hypocrite. Or was it last done up a while ago?
I did that, I realised I can't touch it further. Do you want to pop out first?
Yeah.
Will we go? I'll get emails from Steve.
Yeah.
Hey, Christian. Hi, John. Fresher air, not exactly fresh air. The magnificence of the lake. But are they going to break again at 12 o'clock? Well, I'll get a bit later. So 10 minutes. I'll get a chance. 12:30? Should get a chance to arrange the lectures. Well, no, I don't. Danny, sorry.
Yeah, sure.
You're going to go till 12:30?
Yeah, that's the plan.
Okay. Because in terms of rearranging the deck chairs,
Yeah.
I'll do that after the lecture.
Yeah, that's what he asked for. He asked for another one at, I guess, 12:10.
Well, looks like it might be.
Yeah.
There will be another break.
Yeah, I mean, it would seem more sensible in a way to do one at 12:30, so you can do the deck chairs. Yeah. Yeah. Well, let's see how. Yeah.
Right. Yeah.
Oh, sorry. No. Yeah, go on. Apologies. There you go.
Are you sure with that?
Yeah, I'm happy.
Yeah.
That's fine. Just pay attention to what's going on now. Seeing it's supposed to be directed at me.
Yeah, this is all great.
Two decades. 2 decades.
Have we made up getting there again? Yeah, well, they're meant to. Yeah.
No, they're not. Saying they don't drop the ball. No, sure not. I mean, do you think there's anything exactly.
So we were to call the short adjournment, the brief adjournment, dealing with the right of plaintiff to sue defendants in domicile and bring in claims under Article 6. I'm going to move back to Article 23 in relation to issue 1, if I may.
Yes. Before you do that,
Please.
the wrinkle on Mr. Mirabeau, is that going to be dealt with somewhere? This is the post January 2010.
Yeah, post to when he ceases to be a partner,
Correct.
whether or not he.
That's the only outstanding wrinkle.
I think that's the
isn't there?
only outstanding wrinkle.
You
We
rely on what you say in your.
We rely on what we said in our skeleton. Essentially, in relation to Mr. Mirabeau, once he ceases to be a partner, he doesn't fall within the scope of the
Understand.
exclusive jurisdiction clause.
And obviously, separate considerations for the Mr. Amuzagar, forgive me if I'm no disrespect intended, and Mr. Argar.
Yeah.
Insofar as their positions are different, you address that in your skeleton.
Yeah,
argument.
absolutely.
And the only wrinkle, just so we don't overlook anything, the only wrinkle on the facts is the Mirabeau wrinkle, Mr. Mirabeau.
I think that's right. Yeah.
There's no challenge to any other aspect. No. Thank you very much.
No. And then obviously I'll also just mention at the end the Pictet Bahamas.
Yeah, of course.
And
Yes.
Pictet Asia.
Of course.
Albeit that's a very brief point. So if we could then, it is perhaps just worth turning up the basic clause we're dealing with. Authorities Bundle 5, tab 54, 1816.
What do we want, Article 23?
Yes, just Article 23. I think I took you to it.
Yes, you did.
Obviously, the first part of it is the subject of what we've already dealt with in relation to issue 2 and as we've set out in our rubric and so on. But we're now dealing with A, whether or not terms were provided, whether or not the agreement, such an agreement conferring jurisdiction, which is what the tail of paragraph 1 says, such an agreement conferring jurisdiction shall be either in writing or evidenced in writing, or in a form which accords with practice which the parties law established, and so on, international trade or commerce. We are only concerned with the question whether the agreement conferring jurisdiction was in writing or evidenced in writing for the purposes of issue 1. And what this is concerned with is it's only concerned with the position in relation to Pictet prior to 2012.
And so Mr. Bertorat as well.
Yes, and Mr. Bertrand, quite right. Yes. And And again, we have relevant case law in relation to this. So again, I'm going to just work through the case law and then go to the judgment.
How many cases?
3. I don't think I'm going to... I will deal with some of the UK case law, which is referred to in judgment when I come to the judgments. So, if I may, start at Authorities Bundle 4, tab 36.
Back to Salotti.
Back to Salotti. So it's back to Salotti, but we're not dealing with the general interpretation provisions, albeit those are obviously material to this analysis because they require a strict construal. But we're actually picking it up at 1272 under the first question. Because the first question that was referred in Estes Salotti was whether a clause conferring jurisdiction, which is included among general conditions of sale printed on the back of a contract signed by both parties, fulfills the requirement of a writing under the first paragraph of Article 17. So, whilst in domestic law it might be thought that this question would be relatively straightforward, it was one that warranted reference to the Court of Justice given the concerns that existed in relation to it. And you'll see that in paragraph 9 of the judgment, what the court does is refer back to those considerations of strict construction that I took you to when I was referring to the terms of Article 23 more generally. Taking into account what has been said above, it should be stated that the mere fact that a clause conferring jurisdiction is printed among the general conditions, one of the parties on the reverse of contract drawn up commercial paper, does not of itself satisfy the requirements of Article 17, since no guarantee is thereby given that the other party has really consented to the clause, waiving the normal rules of jurisdiction. So in a way, this is going back to those concerns about strict construction and consensus again. And it's otherwise in the case where the text of the contract signed by both parties itself contains an express reference to general conditions, including a clause conferring jurisdiction. And then I would just ask you to read through paragraphs 10 through to 12. So we emphasise the point that is made in the second sub-paragraph, paragraph 12, where it said that this view of the matter is valid only in the case of an express reference which can be checked by a party exercising reasonable care, and only if it is established that the general conditions, including the clause conferring jurisdiction, have in fact been communicated to the other contracting party with the offer to which reference is made. Now, in many ways, we say, again, it's this early case that provides the clearest answer. The question is, were those general business conditions communicated? And we say plainly not prior to 2012. And that, again, would reflect both the concerns about consensus and the strict interpretation requirements that we've seen earlier in Estes Salotti concerning the proper interpretation of Article 23. But there are two further cases that I want to, European cases I want to take.
You stand for the proposition that for terms to be incorporated, there must be communication in fact,
Yes.
whatever the circumstance.
Yes, for these purposes.
Whether on the front, the back,
Yes.
the previous offer and so forth, it's communication in fact. You say this stands for.
Yes. Because that is consistent with both the principle of strict construction of Article 23 and the need for proper consensus in relation to it, which is emphasised in those general admonitions as to the interpretation of Article 23 that we saw previously.
Yes,
Then if we could go to the next case, which is Authorities Bundle 5, tab 50. Beginning at 1685. Perhaps just worth picking up the head note to give the court some context as to what was actually going on. 1685. So you have a situation where the bond issuing prospectus contained the exclusive jurisdiction clause, but the claimant in this case had actually bought the bonds from an intermediary, and the question then arose as to whether or not the claimant was bound by the exclusive jurisdiction clause. And the court's judgment begins at 1706. And you'll see in paragraph, if one goes over the page to one or two pages to 1708, you'll see the introduction to the court's consideration of the dispute in the main proceedings and the questions referred for a preliminary ruling. So 10 outlines very broadly the bond issuance. And then 11, the general rules governing the programme and economic and legal conditions of the bonds were set out in the issuing prospectus. In the present case, that prospectus was approved in advance by the Irish Stock Exchange, which incidentally has never been contested by the parties concerned. The prospectus remained available to the public on the website of the Irish Stock Exchange. And then 13 to 15 simply set out the scheme or arrangements that resulted in profit investment buying section of the bonds. If we go on then to paragraph 19 on 1709, you see the questions that were referred in this case. Rather, one of the questions that was referred. It's the second question that's obviously important for us. And then you'll see that in fact the court chooses to answer the second question first on page 1710. The reason for that's articulated in paragraph 21. And then if we go over the page to 1711, I just ask the court to read through paragraphs 24 through to 29. So there, what is being dealt with by the court is the question whether or not the exclusive jurisdiction clause can be seen as incorporated to the primary purchaser, essentially. And then at 30, if so, it's also for the referring court to determine whether the contract signed by Ready and Profit, Ready being the intermediary, Profit being the claimant, upon the sale of the bonds on the secondary market also mentions the acceptance of that clause or contains such a reference. If that's the case, that clause must be regarded as enforceable against Profit. So essentially what's being said is, look, there are circumstances which must be assessed by the National Court where you've published a prospectus, the primary purchaser is going to be bound by the exclusive jurisdiction clause, but only if the contract signed by the parties on the issue of the bond expressly mentions the acceptance of that clause or contains express reference to that prospectus. And then it goes on and considers the position in relation to the claimant here. So this is the second part of the second question. And there's consideration of situations in relation to bills of lading in paragraph 33, and actually in 34 there's reference to the Articles of Association discussed in Powell-Dufferin. But just picking it up in 36, in view of the case law set out in 33, 34 above, that question about whether or not the exclusive jurisdiction clause is binding must be answered in the affirmative if it's established, which is for the referring court to verify that the clause is valid in the relationship between Commerce Bank, so the primary bond issuer, and Ready, the intermediary, the first subscriber of the bonds. 2, Profit, by acquiring those bonds on the secondary market from Ready, acceded to the latter's rights and obligations attached to those bonds. And Profit had an opportunity to acquaint itself with the prospectus containing that clause, which implies that the prospectus is readily available. Consequently, the answer to the second part of the second question is that Article 23 must be interpreted as meaning that a jurisdiction clause contained in a prospectus produced by the bond issue concerning the issue of bonds may be relied upon against a third party who acquired those bonds from a financial intermediary if it's established, which is for the referring court to verify, the clause is valid in the relationship between issuer and intermediary. The third party, by acquiring the bonds on the secondary market, succeeded to those rights and obligations, and the party had an opportunity to acquaint himself. There's something of a repetition. So then at 38, as regards the third part of the second question, the referring court asks the court, in any event,
Well, that's not relevant.
it's not relevant here. But then 39, it follows from the case law that one of the aims pursued by this is to ensure that there's real consent on the part of persons concerned. That's just emphasised in relation to all of that. So what we have here is a situation where it was said that it was for the National Court to assess, but you could have the exclusive jurisdiction clause binding between the primary issuer and the intermediary, and then if these requirements under paragraphs 36 and 37 were met, that it would also apply in relation to the position of the third party acquiring from the intermediary. Now I'm just going to divert here, if I may, to the judgment, just to deal with this issue before I go to the next case. And the paragraph that I need to go to is at 118 in the judgment. I'm going to come back to the proceeding reasoning in a moment, but just picking it up at 118 since I'm dealing with profit investment now. The judge at 118 refers to profit investment, and then he looks at paragraphs 28 through to 31 and paragraph 37. And he says, this reasoning indicates, this is at 119, that a party who signed a contract containing express reference to terms and conditions which in turn contain a jurisdiction clause, is bound by it without any additional requirement that the terms and conditions be positively made available to the party. In profit investment, the requirement of actual communication of the terms and conditions only arose in relation to a subsequent purchaser in the secondary market who'd not signed a contract containing an express reference to either the jurisdiction clause or the prospectus containing it. Now, with respect, we say you cannot assume that that is the reasoning or find that reasoning in profit investment itself. There's nothing in profit investment that says, no, there was no need for the terms of the prospectus to have been communicated to the primary bond purchaser, which is essentially what the judge is saying here. He's saying, in profit investment, there was a requirement to ensure that there was a contract specifically referring to the prospectus or the clause in relation to the secondary purchaser, but not in relation to the primary purchaser. We just say you can't get that from that judgment.
So your thesis is that there's a unified requirement of communication in fact, but that communication in fact includes opportunity. In other words, you can't simply, by not looking at something that's obviously available, say, I wasn't communicated with.
Well, yes, and that's why the term readily available is used by the court, exactly. So,
or opportunity to equate.
Yeah.
But don't you get that distinction from paragraph 29, the answer at paragraph 29, and then moving on to the second part of the second question, the answer given at 36 and 37?
No, we say, look, in 29, what is being said here is the prospectus was out and it was readily available. It was available to this purchaser. That in those circumstances, it's important that the contract signed by the parties on the issue of the bond expressly mentions the acceptance of the clause or contains express reference to that prospectus, which is for the referring court to verify. That is not impliedly saying you didn't need to communicate the prospectus to them. Now, I completely take my lord's point that communication is not, in the context of a share prospectus, actually sending it specifically, but it is making it available. And to read that paragraph as saying, no, it didn't matter if it was available, is just wrong. So that's why we say, yes, there is a difference in language, my lady, you're absolutely right, and that's what the respondents rest on and what the judge is doing here. But we say that's just not a sustainable reading of this, given the context that we have from Estasis Salotti about the importance of informed consensus and communication. In other words, 29 is not abrogating the need for communication in relation to the primary bond purchaser, would be another way of putting it. And that's why we say that the judge has gone wrong at 119 in his judgment. That then takes me to the third of the European cases.
The concept of ready availability is quite difficult here, isn't it? And there's no suggestion, indeed on the contrary, that the simplest of inquiries would not have produced the clauses in question.
I'm not in a position to suggest otherwise at this stage, but what is different is, of course, in relation to the prospectus, as I took you to at paragraph 11, that was a publicly available document.
I understand, but that's why I'm interested in your concession to my lord, that ready availability is relevant.
Well, in relation to these issues, the readiness of the availability is it being publicised in the context of the prospectus.
Right, so you mean publicly available, not readily available.
Well,
that's not a criticism. I'm just trying to
get
a grip.
I think it would be inconsistent with the position adopted in Estasis Salotti if the readily available consideration didn't require the communication of the terms. And what is essentially being said in the profit investment case is where you've got something that is publicly available, it is communicated to all those that are purchasing the bonds in those circumstances.
Something can be readily privately available. if you're banking with somebody, you're going to be banking on terms.
Well, I agree, but the point I'm making is that when we go back to Estes Sasolotti, what was required was specific communication of the terms. And so what profit investment is saying is in the particular circumstances where something is publicly available, then in those circumstances, that will suffice for the communication requirement. It's perhaps worth just going to this third case in relation to it, because I understand the point that communication is to some extent a broad concept, and there are various glosses one can place on it, but we say communication in the context of a private relationship of this sort must be the provision of those terms.
Right, so if you have to ask, that's not readily available. Is your solution?
Yes, exactly. So if we could go to tab 49, it's in the same bundle, the Hosig case. It begins in 1660, but the court's judgment in relation to the relevant question begins at 1680. And here we have a situation where there is a debate about whether or not certain terms were provided. And by its second question, which is appropriate to consider first, the referring court asks in essence whether Article 23 must be interpreted as meaning that jurisdiction clause such as that at issue in the main proceedings, which first is set out in the client's general terms and conditions, referred to in the instruments witnessing the contracts between those parties and forwarded on their conclusion. And secondly, designates as courts with jurisdiction those of a city of a member state meets the requirements for the provision relating to the consent of the parties and the precision of the content of such a clause. So it's setting out there what the question is. So it's a preliminary reference question. And what are the criteria in circumstances where there are terms and they have actually been forwarded? And then one goes on over the page.
Sorry, it's my fault. I'm behind you. What page?
I was at 1680.
Thank you very much.
And I was just reading the second question. So the court's asking, what are the legal criteria? So this is a preliminary reference question. Tell us what the law is in relation to this. And then 29, taking account of the objectives and the general scheme of that regulation, and in order to ensure the uniform obligation of that instrument, so that's Article 23, the concept of agreement conferring jurisdiction must be interpreted not as a simple reference to national law, but as an independent concept, which is obviously what we've seen in relation to these matters more generally. And then at paragraphs 31 down through 33 to 34, what we see is, in particular at 33, with regard to the requirements set out in 23.1, it must be pointed out that the provision provides in substance for the formal requirements and mentions a substantive condition relating to the subject matter of the clause which must concern a particular legal relationship. So that's talking generally about 23. And then it says that in the present case the substantive condition is fulfilled. And then we go to 35. Regarding the formal requirements, should be recalled first that according to the wording of 23, an agreement conferring jurisdiction must, in order to be valid, be in writing or evidenced in writing in a form which accords with practices which the parties have established or international trade or commerce. And then 36. Furthermore, ensuring the real consent of the parties is one of the aims of Article 23.1, justified by the concern to protect the...
Sorry, just going back, paragraph
so sorry.
25 is not quite right, is it? It's all, aren't they? They're separate requirements.
They are. You are quite right.
So it's a misstatement.
Yes, you're quite right. They are alternatives A, B and C.
Thank you. Sorry, so paragraph 36.
No, paragraph 36 is just emphasising the consent requirement. And then 37 is emphasising the importance of a national court to even considering whether there was in fact the subject, whether the jurisdiction clause was in fact the subject of consensus between the parties, which must be clearly and precisely demonstrated. So this is echoing the general interpretation points that I emphasised in relation to the general interpretation of Article 23. And then picking it up at 39, 38 is referring to the Advocate General. As regards a situation such as that at issue in the main proceedings, in which the jurisdiction clause is stipulated in general conditions, the court has already held that such a clause was lawful where the text of the contract signed by both parties itself contains an express reference to general conditions, which include a jurisdiction clause. This applies, however, only in case of an explicit reference, which can be controlled by a party applying normal diligence, where it is established the general conditions contained in the jurisdiction clause was actually communicated to the other contracting party. So it goes back and uses, although it's citing profit investment, what it does in 40 is emphasises the strictness of the interpretation of the term communicated, going back to the Estes Salotti judgment that I took you to. So, my Lord, whilst one can accept that the concept of communication may be broad, in a way, the situation in profit investment of a publicly available prospectus can be seen as almost the extreme end of the possibilities of communication that's being countenanced here.
Well, trying to make sense of 40. What is meant by, what is added by the explicit reference, which can be controlled by a party applying normal diligence?
It means before signature that one reviews and is able to consider. So it's the idea which is emphasising the consensus, and as put in 36, the potential to protect a weaker party, that it is critically important that the terms are actually communicated when the relevant contract is...
So you've had input?
Yeah, or the possibility to have input, exactly.
Well, that's what's so interesting, possibility. You can send the 25, 30, 40 pages of single line provisions, communicate them, and the receiving party can decide not to read them because they're far too long and detailed and boring. And nevertheless, real consent on this analysis, a figment, in fact, but that's the way it's approached, will be held to exist. So the real consent point has its limits, doesn't it?
Of course it does. I mean, as we all know, as we subscribe to almost anything in any circumstances, that's true. But what is being said here for the purposes of the jurisdiction clause is that it must have been communicated to you so that you at least had that opportunity to control.
But even that has its limits, as we've already established, namely that if something's on the stock exchange website, then if you're an onward purchaser, then you're going to have to be acting with probably more than normal diligence.
Well, yes, but I mean,
for there to have been actual communication.
Well, that's exactly why I said, in a way, profit investment is the extreme end of the limits of what constitutes communication here, because what you see in profit investment is, even as a secondary bond purchaser, yes, the terms are available to you because they're publicly available to you, and in that sense communicated, but you also have to have signed an agreement specifically referring to either the clause or the prospectus. And so that is why we say, in the context of the interpretation of Article 23, when this requirement of consent and consensus is important, that it was necessary to actually provide general business conditions when you were signing off on opening an account, albeit that the account documentation did refer to, on its reverse, general business conditions.
Right, and you'd affirmatively say that the fact that I obviously knew that you had terms and conditions because you're the sort of person who does, doesn't help you if you don't communicate.
Yes, I do say that, because that is... I quite understand that in domestic law we may approach these things differently, but for the purposes of the European law analysis under Estes Salotti and Hosig, it's applying a stricter test in relation to these matters. So yes, we say that, and essentially we say that is the relevant law, and that profit investment is not qualifying that in the way that the judge seemed to seek to do in paragraph 119 by saying, no, well, it didn't matter whether or not things were communicated to you. And then I think we need to go back to the judgment, if I may. I'm just going to pick it up where I left it at 120. And at 120, the judge refers to Hosig and quotes a number of the paragraphs I've just taken you to. And he accepts that the Court of Justice's statement would appear to suggest that the jurisdiction clause in general terms and conditions expressly referenced in a contract is not binding unless the terms and conditions have actually been communicated to the counterparty, which is what we say Hosig does say. The issue didn't in fact arise because in the case before the Court of Justice, the terms had been communicated to the counterparty. Now, we accept that they had been communicated. And then he says, PIF submits that the statement in paragraph 40 should nonetheless not be regarded as obiter, I'm so sorry, because the Court of Justice was clarifying the law. I don't accept that submission. Had any issue as to the need for actual communication arisen in Hosig, the Court of Justice might reasonably have been expected to grapple more fully with the implications of whatever it decided, including whether profit investment had been overruled and to what extent. Now, with respect, the judge there is drawing on a doctrine that doesn't really exist. Because when you ask the Court of Justice a preliminary reference question, it is providing you with its answers as to what the law is in relation to the issues arising. It is not opining on the fact. It obviously has the factual context within which it then provides its answers. But to talk about a preliminary reference as obiter is just not the right way to analyse this sort of judgment. And the fact that the Court of Justice itself says, well, we know that the terms were forwarded, well, we're setting out the legal structure and conditions under European law for the consideration of these issues, doesn't mean that you can set aside that interpretation of paragraph 40 of Hosig. Particularly when what you're doing is setting aside that interpretation in order to maintain your tendentious view about profit investment in paragraph 119. So we say the judge is right about the interpretation of paragraph 40 of Hosig. He's wrong to try and ignore it as obiter, and he's wrong to try and use that analysis to support his view of profit investment. I should just conclude the paragraph. As I note above, the Court of Justice in profit investment didn't require actual communication save in relation to the secondary market purchases. So that's why he's using this obiter analysis. And it's just wrong. It's not sustainable. And then he says, accordingly, I consider the Court of Justice's decision in profit investment, and what I'm going to come back to, the 3 Court of Appeal decisions I discuss above, constitute binding authority to the effect that no requirement of actual communication exists. Well, with respect, that's just not a tenable conclusion. And if I may, I'll just turn back to what he refers to as the 3 Court of Appeal judgments. He sets those out, or refers to them. Paragraph 114 is the principle.
And your submission is that these 3 decisions are wrong?
Yes.
Proceeding on a misreading of Salotti.
Yes.
And it's not a situation where Hosig has come along and changed the law in some way. They were wrong from the beginning. And our jurisdiction to depart from these 3 decisions?
Well, it's on the basis that you have clear European authority in the form of Hosig that is confirming the earlier line of authority in Salotti, which says that a superior set of laws applies here and explains the requirement of communication. And I don't understand that is actually challenged as an entirely proper situation where the Court of Appeal can depart from what otherwise would be binding the judgments. But yes, that's the situation in relation to those. Your Ladyship has clearly been through this section. I was going to deal with it, but I think perhaps it's not necessary.
Please, it's important. So.
I just asked the court perhaps just to read through paragraph 114 and the quotation from Credit Suisse.
Yes.
Just so you have the whole case to refer to, it's Authorities Volume 1, Tab 1.
Sorry, Authorities.
Authorities Bundle 1, Tab 1.
Yeah, Credit Suisse.
Now, to be fair...
Please, just pausing.
Please.
So, in Credit Suisse, again, it's a dreadful thing to say, but it's looking at the fairness of the situation, what the Court of Appeal in a way was thinking, what may have been part of the thinking is, well, if there's express reference to conditions, and you sign up to those, and you don't ask for them, you don't exercise reasonable diligence, whatever the phrase used here, reasonable care, then sort of that's why it's enough.
We say it's a different standard.
Can you help me, which is my fault? I just looking at paragraph 115, where the judge says doesn't grapple with the point made in paragraph 12 about the general conditions. Was paragraph 12 under question 1 or 2 in Salotti?
2.
In
2. So that was the paragraph I took you to.
Yes.
At the opening of these submissions, which emphasised the importance of consent. I mean, I'm happy to go back to it, but I was going to say the judge is actually being very fair about the Court of Appeal and saying, well, look, this reasoning doesn't actually grapple with Estes Salotti, and we say he is there effectively recognising that the Court of Appeal was applying a different test from Estes Salotti. He then goes on to try and navigate his way through profit investment and Hosig to say, actually, the Court of Appeal conclusion is a sound one. And we simply say, well, no, actually, it wasn't. And what we've got are post-Court of Appeal judgments from the European Court explaining that and confirming the earlier analysis in Estes Salotti, which I quite understand your Ladyship's point, that it sets a different threshold, and that under different schemes of law, one might have greater degrees of essentially caveat emptor or caveat contractor.
Just Sherdley is where?
Sorry, I don't have that in my notes,
No,
so
don't
I'll come
worry,
back.
don't worry.
Sherdley.
Authorities Bundle 1, my lady, tab 9, page 152, I
Thank
believe.
Thank you.
I don't want to hold everybody up, that's fine. Thank you.
I should say that what we have then after...
That was Lord Newberger. Sherdley.
Yes.
Actually, the judgment was given by Lord Justice Ricks, but Newberger was part of the
Lord
decision.
Justice Ricks is also pretty
Yes.
formidable.
Yeah.
Not saying he's necessarily right, Mr.
No,
Okay, so
look,
paragraph
I'm not for a moment doubting the formidable nature of the intellect and assessment that was undertaken in relation to these later cases particularly, nor indeed the quality of the judges in any of these cases. That is not the point I'm making at all. The point I'm making is simply that whatever the motivation for the reasoning in relation to those Court of Appeal authorities, particularly Credit Suisse, it doesn't grapple properly with the points on Estes Sassoloti that this judge recognised, and inevitably doesn't grapple with the subsequent European case law that confirmed
And
this.
just again, paragraph 117 of the judgment, to be accurate, it's Ross J, as he then was, not Fraser J. What caught my eye, it can't have been Fraser J, so
Yes, I'm sorry. I don't
that's,
know.
no, it's not your fault. That's fair. Okay.
Yes.
Thank you.
But I think the other thing to bear in mind in relation to those subsequent cases is that they obviously draw upon very heavily the reasoning in Credit Suisse that has been touched upon here. I think there's one further point in relation to this that is perhaps worth just providing. In the light of the provision of extracts from the new Briggs in relation to various other issues on Article 23, we were briefly looking at those points that Professor Briggs might make in relation to these issues of formality. It's not in the bundle. I have some copies of the relevant section, if I may just pass them up. Might I pass those? Thank you. I think someone has actually included a potential tab number for a bundle, for an authority bundle if that's of use.
All right. 64.
Yes, 64. Well, it's the suggestion. If there's no objection to it going into the authority bundle.
Right, now how much of this do you want us to look at?
I don't need you to look at it. We've marked it up in general terms in terms of the discussion of the relevant issues about bound in writing. But actually, it may be easiest to pick it up at the bottom of 182.
Thank you.
So Hojik was which year?
2016, I think.
So there must have been academic discussion about it and debate about its effect or its impact on these 3 earlier Court of Appeal decisions. Has there been anything that anybody's found?
I don't think we've seen anything. I think we've included one article from the
Right.
Tang about issues concerning Article 23, but it doesn't deal with this, so this may well be the only material.
Thank you.
Right, so Hosig is footnoted at 41 at the bottom of...
Yes,
Right.
Hosig, and Estes Sassolosi's Hosig is footnoted at 41, which was actually the very short point I was going to draw the court's attention to, that in the view of Professor Briggs, that when one looks at Hosig and Estes Sassoloti, in his view, those probably do supersede the judgments of the Court of Appeal, notwithstanding the eminence of the judges delivering them. But I won't.
So this is Professor Briggs effectively disagreeing with you or supporting you.
Supporting.
Why?
Because he says essentially the analysis in Estes Sassoloti and Hosig, and there's a further case called Say Home and Gardens, these probably supersede the National Court decisions in 7E, such as 7E.
So where's that?
I'm sorry, it's just
my
in footnote 41.
Yes.
Over the page at 183.
But it says if a party signs a document which refers plainly enough, then that's enough.
This should satisfy the requirements of the article. That's
Yes,
the
but-
point I was looking at.
Yes, so I'm so sorry, but it's the trading, it's containing the trading conditions. He says, referring to, we say Estes Sassoloti and Hosig make it clear that in those circumstances, you've got to have had those trading, those conditions communicated to you. And he's then saying that in relation to those matters, one should adopt those cases as superseding the position in the Court of Appeal.
But then he supports the judgment under appeal,
Yes, he does.
taking a sensible and practical approach to whether the signed documents evidence consent to the agreement which they plainly did to the same effect.
Yes.
I mean, is there scope for an analysis which is stand back and ask yourself on the facts of this case. Was there real consent? And the facts of the case are two commercial parties, properly advised, lawyers at hand, clear express reference to conditions, every opportunity to call for them if they were interested in them, and on a pragmatic view, this court should conclude that there was in all the circumstances real consent, even though the actual conditions were not supplied.
Well, we say that would be going too far because the requirement in Article 23 is an agreement to the conditions being in writing or evidenced in writing.
Yes.
And in the agreement to the jurisdiction clause being in writing.
Yes.
And in those circumstances, we say it is clear from Estes Sasselotti, Hosig, and indeed Profit Investment, that means you need to have the exclusive jurisdiction clause in order, as it's put in the language of the European Court, to control it, and that it needs to be communicated to you. That is, after all, the requirement set out in paragraph 12 of Estes Sasselotti, and it is the requirement repeated later in Hosig. And so we say no.
We get the notion even in Hosig of reasonable diligence coming into it, or reasonable care. And then you get this suggestion in the footnote about, taking a sensible and practical approach to whether the signed documents evidence consent to the agreement, to the evidence.
That's of course right, but it has to be with the communication. I don't think anything in what Professor Briggs is saying is that one can abrogate the requirements of communication in those circumstances.
Or sufficient communication.
All right.
Well, anyway, you say
let's. I think we've got a certain amount to get through. So we'll find a convenient point.
I think now is probably a convenient point, and I'll sweep up the remainder of the issues thereafter.
Right. So we got through issue 1, have we then?
We've done issue 1, 2, 3.
And you've got
4,
5 and 6.
5 and 6, which I can deal with extremely briefly in a way, because.
All right. Well, let's. How long would you like to spend on those?
I'm very happy to deal with those very briefly now for 5 minutes.
No. I think we have to have regard to others. And but if we were to resume at 15:15, could you finish by 15:30?
Oh, certainly. Yes.
All right. Let's do that.
Yeah, always. Sorry.
May I take a...
Sorry? Well, let's see what he said.
Do we have? Yeah. Right. Yeah.
They're great working conditions, aren't they? Just absurd. Is it?
That's the size of this.
It is utterly absurd. But they'll laughing themselves. Is it? No, no.
Yeah.
I brought my letter.
I don't know how you're going to fit that in.
Well,
It's your lucky letter.
that is the problem. Yeah. I should have brought smaller files, but I can't see them. They're useless. Completely hopeless. I got rid of mine. Right.
You're welcome to have things in front.
No. That's very kind. I'm just trying to see if. No, I'm going to get one. I'm going to get one stow there, and I'll get one stow on the seat. And that will be enough. I don't think anyone's been referring to supplemental volumes.
No. Not so far anyway.
Not so far.
You see at the end of the race.
Well, exactly. Right.
Do with host.
How long are you going to need?
25 minutes, if possible, please.
Right. Well,
I might be able to do it quicker, but
we'll see how we get on.
slightly depends on how Jonathan thinks.
Yeah.
How long should you do?
And then I'd like to get through at 3 o'clock. I'll try that. I think that's right. Yeah, I think that's realistic.
So when are you going to finish today?
Well, I'm just going to try. Yeah, good. I want a stow on there and a stow there.
Right.
I don't know.
Oh, sorry.
On top of yours.
sorry.
Yes, absolutely. But I need you to get in before I move.
Half an hour and a half.
Well, we'll see.
Chelsea. Yeah. Well, he's just said he's going to be an hour. Yeah.
We'll see.
Sorry? I mean, if he's not addressed by this, then that's fine. I would think probably if Pen starts to finish, I'd finish about. Sorry? Yeah, that's right. So I'd finish at 4:50. I mean, it depends how much there is up to. Sorry?
I'd like to have about 20 minutes.
Yeah. No, I think
4:10, wouldn't it?
well, I think there's a recognition on the middle side that we're doing the heavy lifting. I think. I mean, I think what needs to be realistic, but it just depends on how they go. But your only point is,
Well, assuming you cover the law.
yeah.
Well,
You're already toothpaste back in the top pocket from which it was built, and probably
You're now in there forever.
I know. It's kind of scary.
I'll try now. You just sit there. I mean, there's no way I'm going to get stuck in this court.
Building himself a little
I'm northern there.
in my room.
So tempting
Silent floor. Right.
I will just deal very briefly with issues 5 and 6. So, in relation to our formulation of issue 5, but I think R51 and the Respondent's version of issue 5 are focused on the position of Monsieur Mirabeau and whether or not he can rely on an exclusive jurisdiction clause between the bank, of which he was a partner, at a time when he ceases to be a partner. And we say there is no good basis for him to do so.
Is there any reason why this pops up where it does, as opposed to sort of in some sort of scope argument? Anyway, you've both.
I think we've both separated it out because it's a binary question of as to whether or not it comes within the partnership reliance that I think is placed, and therefore raises a slightly different question. Because I think there isn't an issue as to whether or not the scope of the exclusive jurisdiction clause, if it's to apply, should apply to the partners. And therefore, it becomes a question of whether or not it extends to him qua partner.
It's common. There's no challenge to the judge's findings that the partners, the relevant Berteran and Mr. Berteran and the others who are relevant, have the benefit of those exclusive jurisdiction clauses. This is the only issue.
Yes, if and insofar, obviously, as they apply. Yes.
Yes.
Yeah. Yes. But yeah, that is correct. In relation to the non-partners and in relation to Monsieur Mirabeau, after partnership, so that's Monsieur Mirabeau after partnership, and then Messrs. Argan and Amusgar. Of course, there is no Article 23 issue that arises in relation to them, and therefore we say that in relation to the claims pertaining to them, the Article 6 analysis is materially different, even if you're against me on everything else. So that's in relation to effectively non-partners, of which Mr. Mirabeau is one for a certain part of the relevant period. And I think that probably deals with both our points 5.1 and 5.2 in relation to the issues. We say a different sort of balancing would be required, and I've referred you to our skeleton argument, our supplementary skeleton argument, paragraphs 60 through to 64, where we talk about these balancing argument issues. As I say, in relation to them, there will be no Article 23 question arising. That, I think, then takes us very briefly to the sixth issue, which is agreed, and that is the question of the appropriate forum in relation to Pictet Asia and Pictet Bahamas, who are potentially important entities in relation to the litigation overall because of their role in receiving secret commissions and other funds. And therefore, we don't want to lose sight of them because including those in the London proceedings may be important for evidential and disclosure reasons, if nothing else. Now, obviously, those two banks, Pictet Bahamas and Pictet Asia, are domiciled outside the EU, and therefore the jurisdiction issue is governed by common law rules, and it's obviously common ground that there can be a gateway via necessary and proper party, but the dispute is as to whether or not England is the appropriate forum for these claims. But of course, the analysis of whether England is the appropriate forum is heavily dependent on the judge's findings in relation to Article 23 and Article 6. And we say that if we are correct in relation to either our arguments on Article 23 or in relation to our arguments on Article 6 in relation to Category C, then that assessment that was carried out by the judge was flawed, and those entities should not be excluded from the jurisdiction, effectively.
To the contrary, if you're incorrect on those matters. So.
If we're incorrect on those matters, we don't have separate grounds in relation to them, and it's for that reason that I've left them to the end, because they are the arguments that arise. They're important, but they are undoubtedly parasitic on the other points that have been raised in relation to the remainder of the legal issues that we've highlighted. And again, we've touched on those in our skeletons, but I'm not sure that there's a great deal more to say without just becoming repetitious in relation to these issues. And it's for that reason that we deal with Articles 5 and 6 rather briefly in relation to these matters, because they are dependent on other things. So, as I say, issues 5 and 6 I dealt with rather briefly, but because of their position in the overall hierarchy of considerations. And unless I can assist the court...
Just the paragraph references for your skeleton on Asia and Bahamas, please.
I think that's paragraph 65, if you give me 1 moment.
Makes sense.
Sorry, 67, which is Core Volume 4, tab 41, page 1051.
Thank you very much.
Thank you very much indeed.
Thank you.
All right. Yes. Quickly.
May it please your lordship, as the court knows, I appear with my learned friend Mr. MacDonald on behalf of Banque Pictet, Pictet and Compagnie, Pictet Bank and Trust, and Bank Pictet and Compagnie Asia. Miss Kagan is somewhere in the ether appearing before this court. Now, Mr. Adkin QC and Miss Benyon appear for Mr. Philippe Bertherat, a former Banque Pictet partner, and as you know, Mr. Marshall QC and Mr. Hatton appear for Mr. Karim Mouzagar, who was employed by Banque Pictet until sometime in 2003, I think. Now, I intend to respond on behalf of the Pictet defendants on the Lugano Article 23 issue. So that involves both the formal validity issue and the material validity issue. And I'll also, if I have time, address our respondents' notice points. Mr. Adkin is going to respond today on behalf of the Pictet respondents in relation to the Article 6 points, which you've heard about, and Mr. Marshall is going to respond in relation to that issue insofar as it affects his client, Mr.
Right. You've agreed to some division of labour, so we don't have unnecessary overlapping.
We're going to try and avoid that, my lord. Now, may I make a number of short preliminary points at the outset, which no doubt the court will already have well in mind. The first is that this appeal is limited to a review of the learned judge's decision and does not proceed by way of a rehearing. And I have in particular in mind the remarks that my Lady Justice Carr made in the Mozambique case at paragraph 83. An obvious point, but nevertheless worth stating at the outset. Second, my lord, Pith's appeal is to be considered with reference to Pith's pleaded case as it was advanced before the learned judge. You've heard virtually nothing about the pleaded case from my learned friends. And the fact that it has subsequently amended that pleading as it has is nothing to the point before this court. And again, I pray and aid what my Lady Justice Carr said in the Mozambique case at paragraph 83. In any event, for good measure, the claimants have acknowledged that their re-amended claim isn't a live pleading against the jurisdiction defendants. Now, the third point I make is, although it would be necessary to look at it in a bit more detail, one can summarise Pith's case against the Pictet respondent shortly, as the judge did at his judgment at paragraph 284, which I think the court has seen already. And at 284, the learned judge said Pith's central allegation is that Banque Pictet and Pictet Europe paid secret commissions to Mr. Al-Rajaan, which were at least in part paid in order to induce him to place Pith's business with Banque Pictet and Pictet Europe, paid from revenue earned by Banque Pictet, Pictet Europe, from Pith's business, and or referable to such revenue. And I paraphrase what the learned judge said in that paragraph. That is a summary, my lord, which Pith's has not taken issue with on this appeal. Now, Turning more to the substance of the matter, the bedrock for the Brussels regime and the Lugano regime which followed it is that jurisdiction is based on a defendant's domicile. And there are, of course, a number of important exceptions to that primary general rule. First amongst those exceptions, in the sense that it trumps all other bases of jurisdiction, including even domicile, is Article 23. The primacy afforded to Article 23 in the scheme reflects the overriding importance attributed, my lord, to party autonomy in the relevant instruments. What is curious then about this particular case, and perhaps unique, is that PIFS is seeking not only to avoid suing the principal Pictet defendants, Banque Pictet in Switzerland, Banque Pictet Compagnie in Luxembourg, where they're domiciled, but it's also seeking to avoid and that basis of jurisdiction is reinforced, as you've seen, we say, by the numerous jurisdiction clauses which are entered into in connection with the banking relationship which PIFS had with Banque Pictet. Now,
your EJCs happen to be for your place of domicile.
yes, yes.
It wouldn't. It's not necessarily.
It's not a necessary. It
But
could.
in this case, they happen to overlap.
They happen to overlap, my lord. That's right. I mean, they could, in accordance with the party's autonomy, they could refer to a completely different jurisdiction. Now, in doing so, PIFS advances what we say is an unjustifiably narrow interpretation of Article 23. And at the same time, certainly in its written submissions, although we've not heard much about that orally, it seeks to gloss the way in which it has formulated its case against my clients. In fact, when one focuses on the language of Article 23 and then looks at the claim as formulated by PIFS, as Mr. Justice Henshaw did at some length in his judgment, it is plain in our submission that Pictet had and has the better of the argument in relation to the Article 23 jurisdiction. And there are four main points.
Are you on grounds 1 and 2, material validity, or?
I'm going to identify what I say are the four main points, and right. they encompass...
Okay, both, all of the Article 23 arguments.
Yes, exactly. Right. First, my lord, the dispute, which is a critical factor in Article 23, the dispute in this case is set out in the points of claim, and there isn't any need or basis for looking beyond that. Now, sticking with the pleaded case is consistent with the guidance given by the Supreme Court in the Opkabi case, Authorities Bundle 3, tab 30, which I don't ask you to look up now, and of course, of this case, in the Mozambique case, which I've referred to. Second, the agreement or agreements conferring jurisdiction on the Genevan Court or the Luxembourg Court are in writing or evidenced in writing. We say we have the support of 3 Court of Appeal decisions and the profit investment decision that those agreements were formally valid, and PIFS has to say, as it does say, that a distinguished line of Court of Appeal judges was wrong and shouldn't be followed by this court. Third, the claims against Pictet in relation to the Pictet scheme are within the scope of the jurisdiction clause as a matter of their Swiss law interpretation. PIFS doesn't challenge the judge's decision on that issue, whereas, as the court knows, we have something to say by way of respondent's notice that the judge, as a matter of Swiss law, didn't go far enough in relation to the various claims. Would you mind just
restating point 3 again? I'm sorry, I lost it in translation.
Sorry, my lord.
This is your third point, that the claims against Pictet are, you say, within
the scope of the jurisdiction.
Within the scope of the EJC?
Yes, in relation to the so-called Pictet scheme. Now, the Pictet scheme has a number of, well, may have a number of heads, the ABC head. But,
sorry, what do you mean the Pictet scheme? You mean the different sorts of claim, the secret commission? Or
by the Pictet scheme, I mean the pleaded case that in response for, in return for making secret commission payments, Mr. Al-Rajaan would cause PIFS to enter into contractual relations with my client, and also as part of that arrangement my clients would establish a series of offshore companies through which Mr. Al-Rajaan secret commission payments could be
Yes,
concealed.
split the profits and hide them.
Yes, exactly.
That's the scheme.
Exactly. So that's the third point. And the fourth and final question is whether the dispute, which my learned friends have set out in the points of claim, has arisen in connection with a particular legal relationship or legal relationships, and that involves largely a factual inquiry, which we say the judge approached and answered correctly. Furthermore, when one applies the cross-check suggested by the Powell-Dufferin case and referred to by Mr. Justice Jacob in Etihad, the suggestion that PIFs, or the question whether PIFs would be surprised by having to pursue claims against Banque Pictet in Switzerland, in our submission, the only sensible answer to that question is of course not. And if the only sensible answer to that question is of course not, as Mr. Justice Jacob put it in the Etihad case, it is very likely indeed that the disputes do not arise from a different legal relationship in connection with which the jurisdiction clauses were agreed. And that's a passage we will come to again, which the judge referred to in the course of his judgment. Can I turn now to the formal validity issue, which is raised by grounds 1 and 2 of PIF's grounds of appeal, and they only concern Banque Pictet's terms and conditions of business prior to 2012, because as far as Banque Pictet Luxembourg is concerned, it's accepted that terms were provided and signed as early as 2000. Now, as far as the judge's judgment is concerned, we say he made no error of law. PIF's agreement to the jurisdiction clauses was sufficiently established for the purposes of Article 23. The learned judge properly followed binding Court of Appeal authority, which remains binding, notwithstanding what the court has said in the profit investment case and hostage case, which I'll look at in due course. On the contrary, we say PIFs misapprehends the effect of those judgments. But even if we're wrong about all of that, we do submit that this court should not depart from a consistent and clear line of its own authority. Now, the court has already seen the learned judge's judgment, I think at paragraphs 80 and 90 onwards, where he sets out the various terms and conditions and the opening and the account opening documents. And I'm not going to invite the court to reread those. You will have those in mind in the course of the submissions that I'm going to make. But pausing there, in our submission, there is no obvious reason, in principle, why a party which expressly declares, as PIFs did, that it had taken notice of or had expressly agreed to the application of general business conditions on the opening of the account, or making some such other arrangement, should not be held to such a declaration. And in our submission, it provides, as the European law requires, the clearest objective manifestation of consensus with all the necessary formality that European law requires. And the learned judge, as you have seen, considered this issue at paragraphs 98 to 122 onwards. Perhaps one should look at paragraph 102, which is on page 360 of the bundle. He refers specifically to the Benincasa case, which makes clear that one's concerned here with an objective examination in relation to the question of material validity. So the judge didn't lose sight of that, because
Sorry, we're on formal validity.
Yes, we're on formal validity.
But you just said material validity.
Did I say material
You
validity?
meant formal.
Then I misspoke, my lady.
Fine.
My apologies. Now,
Right, well, do you I don't think we've gone to Benincasa.
We don't need to go to Benincasa.
Is there any particular passage in this?
What the judge is doing is referring to Benincasa, and he's recognising that what he's concerned with here is the autonomous principle of EU law, because that's what Benincasa says, and that's how he approaches his examination of the questions for the.
Sorry, for me, I'm just struggling. Where is the objective examination point in Benincasa cited in 102?
It's the autonomous principle, my lady.
26. Oh no.
Paragraph 26. The court has consistently held the objectives of the convention include unification of the rules of jurisdiction, so as to avoid far as possible the multiplication of bases of jurisdiction in relation to one and the same relationship, to reinforce the legal protection.
That's not the point you were making as I understood it. You said that it has to be an objective examination. The clearest objective manifestation of
Yes.
consensus.
Yes, and it's not a subjective. It's not a subjective question when one comes to examine the relevant principles. Now, the judge considered the Article 23 1A point at paragraph 110 of his judgment onwards. And he quoted extensively, as you see, under 111 from the Salotti judgment itself. And you will see that he quotes from paragraph 7, where he specifically quotes the passage which says that the question of clauses governing jurisdiction under Article 17 must be strictly construed. So one of the criticisms that came to be made ultimately is the judge had lost sight of this fact. But actually, when he was directing himself with regard to the relevant EU jurisprudence, he specifically cited this particular paragraph. So it cannot be said in my submission that he forgot about this. And what's important about Salotti, one perhaps ought to look at the case itself, because my learned friend, the judge set out, as you see, in these paragraphs, what the court said between paragraphs 9 through 12, the important paragraphs in that judgment. But the important point to take, as I think my lady Justice Carr picked up earlier, is that there are two questions which were formulated before the court, and the court answered those questions separately in paragraphs 9 and 10, question 1, 11 and 12, question 2. Now, my learned friend suggested in his skeleton argument that what the Court of Appeal said had to be taken cumulatively. That's not correct, because there were separate questions which were asked and separately answered. And indeed, when one looks at the ruling of the court, which after all ought to be the important matter, one sees that the court addressed these separate questions separately. And if you want to see the questions which were asked, they're in Authorities Bundle 4 at tab 36 on page 1265. This is in the judgment of the Court of Justice, and on page 1265, towards the bottom of the first column, the first question is: does a clause conferring jurisdiction, which is included among general conditions of sale printed on the back of a contract signed by both parties, fulfil the requirement of a writing under the first paragraph of Article 17? And the second question, in particular, is the requirement of a writing under the first paragraph of Article 17 fulfilled if the parties expressly refer in the contract to a prior offer in writing in which reference was made to general conditions of sale, including a clause conferring jurisdiction to which these conditions of sale were annexed. And those questions were separately answered in paragraphs 9 and 10 and 11 and 12, as I said, and the learned judge refers to those in his judgment. And if one wants to look at the ruling of the court, one sees on on page 1274 under tab 36. Ruling 1, where a clause conferring jurisdiction is included among the general conditions of sale of one of the parties, printed on the back of a contract, the requirement of a writing under the first paragraph is fulfilled only if the contract signed by both parties contains an express reference to those general conditions. So that's the first question, that's the first ruling. And then the second question, the second ruling, in the case of the contract concluded by reference to earlier offers, which themselves made, with reference to the general conditions of one of the parties, including a clause conferring jurisdiction, the requirement of a writing under the first paragraph of Article 7 is satisfied only if a reference is expressed and can therefore be checked by a party exercising reasonable care. Now, we take...
Sorry, forgive me.
Right.
That does not, interestingly, yes, which is in paragraph 12, which is clearly part of...
It doesn't. It doesn't. That was the point I was going to make. It doesn't say that. But there are so and if one looks at the court's judgment in Salotti, having answered the first question that you needed, the mere fact that they were printed on the back of the contract, mere fact they were printed there without express reference, didn't amount to consensus within the meaning of Article 17. In paragraph 12, you'll see that the reason why in paragraph 12 they suggested that they would have had to be communicated in the particular circumstances that we're looking at there was because if they hadn't been communicated, that wouldn't yield certainty. But it's important to realise that the circumstances that the court was addressing in paragraph 12 did not involve an express reference in the terms of the contract, but the contract referred to an earlier offer, and the earlier offer letter itself referred to the conditions. So you were looking at it at several removes. Whereas, when the contract expressly refers to the general terms and conditions, the search for certainty is fulfilled, where the party expressly agrees to the terms of the other party in relation to general business conditions. And that's how we say Salotti should be read, and it is indeed how this court has consistently read Salotti from 1997 onwards. And perhaps I should just show the court briefly what Lord Justice Savile, as he then was, had to say about this. And this is an Authorities Bundle 1 at tab 1. And one sees from page 1 that the question that arose in that case was whether express reference in the written contract to terms which hadn't been supplied at the time of the contract amounted to a clear and precise demonstration that the clause conferring jurisdiction was a subject of consensus between the parties. I'm reading from the holding. And that is what the Court of Appeal indeed held. And if one sees in the reasoning of Lord Justice Savile on page 4 of this section, towards the bottom, H, he says, to my mind, the question is simply whether the express reference in the written contract in the present case amounts to a clear and precise demonstration that the clause conferring jurisdiction was the subject of consensus between the parties. I have no doubt at all that it does. It seems to me that there is nothing in Salotti which begins to suggest where in the written contract itself, there is an express incorporation by reference of other written terms, no consensus is established unless the profferee signing the contract has been supplied with a copy of those terms, or as the judge put it, he has a copy of those conditions in his possession ready available to him. And then he goes on to refer to the fact that the terms are printed on the back. But he says over the page, on page 6, to my mind, the consensus is incontrovertibly established by express reference in the written contract itself. Now, that approach was subsequently followed by this court in the Vertex case, which is at tab 2 in this bundle, I believe. Sir Anthony Clark, Lady Justice Arden, and Lord Justice Dyson, as they then were. And they also concluded that if one looks at the holding at H...
Did they simply follow, or did they independently reason?
I would say that they independently reasoned, but they placed a lot of emphasis on what Lord Justice Savile had said, as one sees at paragraph 32. One of the questions which arose in the case was, well, does the point that Lord Justice Savile made in the earlier case still apply if there were two pieces of paper in which amounted to the contract? And they said, yes, it did. And I don't think it's necessary for me to take you through that at any length. The latest case, which considered this, as my lady knows, is the decision in the Sherdley case, where a panel consisting of Lord Justice Ricks, Lord Newburgh, and Lord Justice Everton concluded that the law was as set out in the Coy's case, which itself referred back to the previous decisions of this court. Now, in our submission, the reasoning in those cases is both compelling and binding on this court. And on the basis of those decisions, the judge's conclusion was plainly correct. Now, PIFs say in their supplemental skeleton, and they say this: these decisions have been overtaken, they say, and their reasoning shown to be incorrect by subsequent cases. And the subsequent cases that they rely on, the profit investment and the Herzig case, which the court has looked at. The judge dealt with the profit investment case in paragraphs 118 to 19 of his judgment, which Mr. Beer showed you earlier today. And in our submission, his judgment in relation to the profit investment case displays no error of reasoning. And one should look a bit more carefully in my submission at what was going on in the profit investment case, which is at Authorities Bundle 5 and 50. Now, as the court knows, a German bank, Commerzbank, issued bonds, and the rules and conditions of the bonds were contained in the prospectus. And the entire issue was acquired by a company called Reddy, and Reddy sold on the bonds to secondary market purchasers. And they sought a declaration of nullity in relation to the sale before the Italian courts, and the defendants sought a stay of the case on the basis of the jurisdiction clause contained in the prospectus. The Italian Court of Cassation, Supreme Court of Cassation, referred to the Court of Justice a number of questions, and those are identified in the Advocate General's advice at paragraph 20 on page 1691 of the report. And the one that we are interested in for the purposes of Article 23 is the second question. Can the requirement that the agreement conferring jurisdiction be in written form, as laid down in Article 23(1)(a) of Regulation 44, be said to be satisfied where such an agreement is inserted into the memorandum that's been created unilaterally by a bond issuer, with the effect that the prorogation of jurisdiction is made applicable to disputes involving any future purchaser concerning the validity of those bonds? If not, can it be said that the insertion of that agreement into the document governing a bond issue, which is intended for cross-border movement, corresponds to a form which accords with usage in international trade or commerce within the terms of Article 23(1)(a) of the regulation? Now, the Advocate General's opinion proceeded in stages, and if one looks at paragraph 37 on 1694, you'll see that he refers to a tripartite division of the question is necessary insofar as the first limb seems to me to be exclusively concerned with the validity of the prorogation of jurisdiction clause in the relationship between the parties to the contract containing that clause, while the second limb relates to whether that clause is transferable to successive parties and securities. The third limb of the question includes both of those issues and concern more generally with the effectiveness of that clause against any purchaser or sub-purchaser of securities. So the first question which the Attorney General proposed for answering was, is the prorogation clause in the prospectus valid vis-a-vis the primary parties to that contract? So in essence, raising the question, or the first question, which was raised in Salotti. So that's really Salotti 1. It's also, in my submission, the same question which this court has considered in the decision of Lord Justice Saville and the Master of Royal Sir Anthony Clark. Now, one sees that in paragraph 39 of the opinion of the Advocate General on page 1695, he said this: the court has held that the insertion of a clause conferring jurisdiction contained in the general conditions of sale of one of the parties printed on the back of a written agreement satisfies the requirement of writing only if the contract signed by both parties contains an express reference to those general conditions. And he refers to the Salotti case. That's Salotti 1, Salotti question 1, which is, as I say, we've looked at, was answered in paragraphs 9 and 10 of the court's judgment in that case. And if one then looks at paragraph 46, one sees that the Attorney General proposed an answer to the first limb of the second question, which we see that the court then took up as follows. I propose the court's answer to the first limb of the second question should be that the requirement of writing laid down in Article 23(1)(a) is satisfied in the case where a prorogation of jurisdiction clause is inserted in a prospectus for the issue of securities, such as the credit-linked notes at issue in the main proceedings, only where the contract signed by the parties mentions the acceptance of that clause or contains an express reference to that prospectus. And again, in our submission, that reasoning is consistent with Salotti answer 1. It's consistent with what this court has said in the cases we have referred to, and the reasoning that the Advocate General suggests is not reliant in any way, shape, or form, as far as one can tell from that paragraph, on the fact that the prospectus was available publicly to anyone who cared to look at it. It's not part of the what the Advocate General suggested. And as far as the secondary market purchaser is concerned, one sees the answer that the Advocate General proposed there at 1697 at the bottom of the page, paragraph 56. He says, I'm minded to answer the second limb of the second question to the effect that Article 23 of Regulation 44 must be interpreted as meaning that a clause conferring jurisdiction contained in an information document created unilaterally by an issuer of financial instruments can be enforced against a third party who has purchased those instruments from a financial intermediary only if it is established that that third party actually consented to that clause under the conditions laid down in the article. So there's a different answer which is being proposed. And in our submission, the different answer is being proposed because of the way in which one approaches the question of a clear evidence of consensus. And there is clear evidence of consensus in our submission, where a party signs a contract which says, I agree to your general terms and conditions. That consensus is sufficiently established for the purposes of Article 23. And in our submission, there isn't a case in the European courts which says that is not enough. And I'm going to come on to the Hossig case in a moment. If one looks at the ruling of the European Court, which one finds on page 1718 of this bundle, under 68, and sees the ruling, the material ruling for these purposes, is that where a jurisdiction clause is included in the prospectus concerning the issue of bonds, the formal requirement laid down in Article 23 is met only if the contract signed by the parties on the issue of the bonds on the primary market expressly mentions the acceptance of that clause or contains an express reference to that prospectus. And again, there is no suggestion that it was material to the ruling of the European Court that the prospectus was available on the Irish Stock Exchange website. Now, in our submission, there is therefore no basis for the accepting the submission made by my learned friend in writing and essentially repeated orally, that the profit investment case can be read as overtaking the reasoning of this court in the cases that I have mentioned. And the judge's reading of that case was therefore correct and not wrong, as my learned friend suggested. So, in our submission...
So you say paragraph 119 is right?
Yes, I do. So, essentially, if that's right, the entire challenge to the judge's conclusion rests on what the European Court said in the Hossig case. And in its first skeleton, it's paragraph 19, and I'll just give you the reference to it. It's CV 11078. You needn't turn it up. I'll read what they say. They said Hossig raised the question whether the buyer's general business conditions, including an ECJ, were included in the contract between the buyer and seller when the buyer had provided its general business conditions during the pre-contract tender process and the contractual documents expressly referred to and recorded the seller's acceptance of them. So that's what they say the question was raised in that case, but that's not correct, and it is a mischaracterization of the issues which were referred to the Court of Justice by the Hungarian court, and our submission betrays the absence of merit in Mr. Beard's case. The case itself is in Authorities Bundle 5 at tab 49. And basically, this was a dispute between a French company domiciled in France, Alstom, and Hossig, a Hungarian company. Alstom was the successor to the rights of a French company called Technos, which had contracted with Hossig for the manufacture by Hossig in Hungary of metallic structures which were to be integrated into power plants in France. Techno's general conditions of business, which had been supplied to Hossig at the outset in connection with the contractual documents, provided that the contract was to be interpreted and subject to French law. Hossig brought proceedings in Hungary on the basis that it was a court having jurisdiction because Hungary was the place of the performance of the service, so relying on Article 5 of the Brussels regulation, I think this was. Alstom raised a plea of absence of jurisdiction before the Hungarian court based on its general conditions. It's important that one sees what the actual questions were, which were raised by the Hungarian court for the European court. And one sees that set out in the Attorney General's paragraph.
I wonder if you're embarking on Hossig at this point. Would this be a good moment to have a break?
I'm very...
I don't want you to have to be rushed through it.
I'm not going to rush through it, my Lord, and thank you.
No. We know when Mr. Beard is going to be rising again at 2 o'clock tomorrow afternoon. I don't think we know how you're dividing the time up between you as respondents.
Yes.
But I presume that you have a programme of division of time, because there are a lot of you to...
There are. We have a plan.
Well, would you just let us know at 2 o'clock roughly? I mean, we're not going to hold you to anything.
Yes.
Provided you're in agreement, you can use the time as you wish. But
I can tell you now, because I've discussed with my learned friends, and roughly, I'm hoping to get through all of this by 3:15. And when I say all of this, that includes all the points which I propose to address.
Well, that's very helpful. All right. We'll start again at 2 o'clock. Thank you.
All right.